Let's come, what? Let's come back from the lunch break, please. Good afternoon. My name is Felicia Orth. I'm a hearing officer appointed by the Water Quality Control Commission to conduct a hearing in WQCC 23-84. We are on the 10th day of hearing and the 20th opportunity for public comment, the 1 o'clock session. I have just a few names here. I will also make a check to see if anyone has arrived without setting up a, a schedule in advance. So the first name I have here is Philip Archuleta. All right. If you would go to the microphone on that side of the table, please. And there are just a few things, as you'll see when I go through this with Mr. Archuleta. I will ask you to spell your first and last name. I will ask you to swear or affirm that you will tell the truth because the commission rules require that I do that. And then I will be running my stopwatch to see that your comment is within 3 minutes. And if you have more to say than can be put into 3 minutes, or if you have spoken in this hearing already, including the week we had in May, I will ask you to put the rest of your comment in writing and share it with Pam Jones. It becomes a record as though you spoke it. So, Mr. Archuleta, will you spell your first and last name?
Good afternoon. Yes, my name is Philip Archuleta. That's spelled Phillip. Last name Archuleta, Archuleta.
Thank you. And do you swear or affirm to tell the truth?
Yes, I do.
All right, I'll start your time.
Okay, good afternoon, everybody. Again, my name is Philip Archuleta. I am speaking here today in support of water reuse for New Mexico, also in support of the oil and gas industry. My background is I am a military veteran, and I do have some background in oil field safety. I was spending time down in the Permian Basin, seeing vehicles come up and down throughout that highway, and some of my beliefs in with this reuse, it could bring down the usage for so much of those water trucks on the 285 out there. Basically a midstream plant out there instead of injecting this water back into aquifers and storage areas out there where we got to worry about contamination. If there could be a desalination or reverse osmosis plant out there, it could create a new point to help these trucks not traveling so much back and forth throughout the area. With this, it also opens up an opportunity for more jobs in New Mexico and can help with, how do I say this? It can basically create new technology usage throughout the state. For me, I personally believe that with all this water that we have to inject back in the ground with the chemicals, we could take that, help out the community by cleaning it up, don't have to worry about these aquifers leaking, contaminating, and now have a safe storage area for it. It's my belief that it could help us not having to waste all the water that we have here in New Mexico, which is short in supply already. Other than that, that's really all I have to say on this topic. Thank you.
Thank you, Mr. Archuleta. Randy Chulik. Okay. Mr. Chulik? You should be able to unmute yourself now.
Mute.
There we go. Can you hear me? I heard one word and then you went mute again. Can you unmute yourself again, please? So, Mr. Chulik, the last time this happened, the person not able to unmute himself exited the platform and came back in. Let me suggest that to you. And Pam, if you would just uh, readmit him promptly. All right. Joseph Sanchez. All right, let's see if Joseph Sanchez can unmute.
Hello.
Oh, hello. Mr. Sanchez, would you spell your first and last name, please?
Josephsanch. Easy.
Thank you. And do you swear or affirm to tell the truth?
Yeah.
Thank you. I'll start your 3 minutes.
All right. So, my name is Joseph Sanchez. My family has lived here for generations and generations, and I feel a deep connection to this land that we live in and those that live in it. So, when I hear that our government here in New Mexico is debating whether to allow the oil industry to dump toxic water waste onto our communities, that they are claiming this water will be clean and safe without specifying exactly how this will be done. Like, are you joking? I understand that you may be seeing dollar signs and thinking that this is the right move for our economy here in New Mexico, but how twisted is that? You see dollar signs about the prospect of poisoning our communities, allowing for toxic water to be dumped on our communities, is not exactly looking out for New Mexicans. It isn't doing what's best for the people, so why are we even considering this as a possibility? There needs to be concrete standards in place to protect the health and environment of our communities and workers, and you must demonstrate these standards. You can't just tell us, don't worry, it's safe. If it is safe, then prove it. Demonstrate and specify these standards. Now, I want to see the good in people. I don't want to assume the worst. I would like to think that you do care about New Mexicans, that you do what's right for our communities, that you have the best interests at heart. So prove me right, please. Please adopt an alternative rule instead that prohibits discharge and reuse off the oil field. Thank you. That's all.
Thank you, Mr. Sanchez. Mr. Chulik, are you able to unmute yourself now? Mr. Chulik? Oh, is that you?
Can you hear me?
Oh, now I
Let's
can.
try.
Yes, thank
Can you
you
hear
so
me?
much. Yes, thank you so much for hanging in there. Would you spell your first and last name, please?
Yes, my name is Randy Chulik. My first name is Randy. My last name is Hulick.
Thank
I
you. Do
live
you
in
swear
Silver
or
City.
affirm? Hold on. Do you swear or affirm to tell the truth?
Yes.
All right, I'll start your 3 minutes.
Okay, thank you. If the Water Quality Control Commission and the oil and gas industry intend to pursue the use of produced water for public consumption, then I ask the NMED to adopt and implement the procedures laid out by New Energy Economy in a petition to withdraw the proposed wastewater reuse rule WQCC 2384 in the following order. Number 1, WQCC shall adopt standards specific to treated produced water based on toxicity assessments before any discharge of treated wastewater is permitted. Such standards will be consistent with and comprise subsection D of 20.6.8.400 NMAC, clarifying what is meant by quote unquote an appropriate level of treatment. Number 2, until treated produced water can be proven to be safe according to scientific standards for reuse in the environment, all pilot projects and demonstration projects utilizing produced water will be confined to industry sites, e.g., oil and gas fields. Off-site oil gas field pilot demonstration projects will not be permitted. Number 3, authorization for reuse of treated produced water in demonstration and pilot projects involving agricultural applications, commercial applications, food crop applications, irrigation applications, livestock applications will be prohibited until standards specific to treated produced water are adopted that show industrial wastewater is safe for reuse. In closing, any research required to establish standards and for purposes of toxicity assessments can be conducted in scientific labs and on oil fields rather than in demonstration and pilot projects. Just as existing drinking water quality standards cannot be measured by what is produced and discharged as waste, fracking waste streams cannot be measured by existing water quality standards. Using one set of standards to measure the other is like using the ACT, the college entrance exam taken by high school graduates to evaluate the progress and aptitude of 12-year-olds entering middle school. It is not practical and should not be done. Thank you for your time and consideration of my comments.
Thank you, Mr. Julik. Is there
Appreciate
anyone
it.
in the room who has appeared in order to offer public comment at this session? There will be at least 1 or 2 more opportunities to offer public comment next week. Probably on Tuesday, we're going to be talking about that after this comment session. Anyone else? Yes, come up to the table, please. Hello, would you state and spell your name?
Yes, my name is Joshua Neal, and it's spelled Joshua. My last name is N as in Nancy, EAL.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
I'll start your 3 minutes.
Thank you. So my name is Joshua Neal. I am a civil engineer from Albuquerque, and I have come here to talk about the current policies regarding produced water and its reuse. So as a civil engineer, I work very closely with local agencies to ensure that produced water or water quality standards or pollution prevention standards are met all across this state. And so I'm very familiar with those. As a moderate myself, my request of the board is that you take a very balanced approach to regulation and protection of our environment and of the natural gas agencies. It should be no surprise to anyone on the board or in this room that natural gas is a huge part of our economy here in New Mexico, and many people around our state, including thousands and thousands of families, rely on the revenues from oil and gas to feed their families and pay their taxes. And I'm confident that we can reassure these families that we will not destroy their livelihoods to protect the environment. As a civil engineer, one of my biggest concerns is drought preparedness. And I can say with certainty that New Mexico is not prepared for a major mega drought. Cities all across the world have something called a D-Day, which is the last day that they run out of water. Cape Town, South Africa was a very famous example several years ago where they were facing severe water drought and did not have enough water to provide their citizens with drinking water, let alone water for other everyday use. New Mexico, being a very arid environment, needs to have measures in place to ensure that when we face major situations of drought, that we're prepared to respond accordingly. I believe that industries historically have led the way in technological innovation and have allowed government agencies to follow suit and use the technological innovations that they've created to help the people. One such example may be rehabilitation of produced water for other uses. Specifically, what I think produced water should be limited to is industrial use in order to protect the environment and to protect everyday citizens. And I think that this process of repurposing produced water has many applications. The number one would be the the reduction of the amount of water that the oil and gas industry requires for their everyday operations. If we're able to reuse this produced water in an industrial capacity and allow natural gas agencies to use that water again for their continued work here in New Mexico, that would reduce the demand that they require from our systems. Another good application could be that repurposing produced water is significantly more environmentally conscious than reinjection, evaporation ponds, or infiltration ponds, which, if you're familiar with those, they just allow the toxic residue to remain until it's excavated.
Please wrap up.
Okay, so in conclusion, I just want to say that taking a balanced approach to produced water regulation would be best for New Mexico. Thank you very much.
Thank you, Mr. Neal. Is there anyone else here to offer public comment? No. Has anyone else reached out online, Pam? All right, so we will return. Oh, wait, I see Hadley Chance has raised their hand. All right, so can you?
Hello.
Oh, hello. If you would please spell your name for the transcript.
Yes, Hadley, and last name is Chance, Chance.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Okay, I'll start your 3 minutes.
Okay, thank you. Good afternoon, Committee.
Wait, ma'am, you muted yourself. Oh, you
So
did?
sorry about that.
Okay.
Okay, good afternoon, Commissioners, and thank you for the opportunity to provide comment today. My name is Hadley Chance, and I'm a third-year law student and student attorney with the Environmental Justice Clinic at Vermont Law and Graduate School. The Environmental Justice Clinic works in partnership with community organizations, tribal nations, coalitions, and other stakeholders across the country to support multi-strategy campaigns to combat environmental racism and advance community health and human rights. This proposed rule as written poses an unacceptable risk to the health and well-being of New Mexico communities, particularly those already experiencing other forms of environmental injustice. Some of the elements of fracking waste include heavy metals like lead and arsenic, and radioactive elements like radium. These chemicals are known to be carcinogenic, and exposures can lead to extremely negative health impacts, such as cancer, nervous system damage, respiratory system damage, immune system damage, or low birth weights. As there is no water standards for this fracking wastewater laid out in this rule, there is no way to know what chemical compositions have been deemed accessible and safe for human health, and this water is supposed to be brought into communities and ecosystems. This will inevitably lead to adverse health impacts. The proposed rule does not sufficiently penalize discharges into surface and groundwaters, and it does not adequately consider agricultural runoff, which could contaminate drinking water, leading to more adverse health impacts. This rulemaking expects fracking wastewater to be used in agriculture, but it does not consider exposures for farm workers who may then be at higher risks for higher rates of cancers, immune system suppression, and other adverse health impacts. Low-income and migrant farmers unable to afford or receive healthcare are likely to suffer greatly from the allowed agriculture uses outlined in this rule. Effectively, this rule without any treatment standards is a stamp of approval for contamination of water under the guise of water conservation. I echo the calls of other commenters for the divestment from a fossil fuel economy and respectfully ask the commissioners to rewrite the proposed rule to prohibit the discharge, disposal, or reuse of treated or untreated produced water outside of the oil field without exception. Thank you.
Thank you, Ms. Chance.
Thank you.
All right. Has anyone else reached out, Pam? All right. And I don't see anyone else who's joined us in the room. So we will end this public comment session and return to the technical case. Again, we expect to have one or two more public comment sessions probably next Tuesday. But if you are interested in hearing about our path forward from this day, I think we're about to have that discussion. At least I hope we're about to have that discussion with council. Mr. Wexler, are you the spokesperson there?
Well, I can't say that I speak for everybody, but I am prepared to talk about the schedule. So let me first just tell you what we have left, and then our limitations, and then the discussion with the other parties. So what we have left is we still have to give our position statement. I'm not going to call it an opening because well past our beginning. We then have Mr. Tischler, who's here with us today. We hope to finish him today because he's in Austin. If he has to spill into next week, we would ask that he appear remotely so he doesn't have to travel again. Unfortunately, Mr. Balch, now that it's afternoon, is traveling, so he's unavailable. Mr. D'Antonio has a previous commitment only this day, so he's been very patient with us. But we think that Mr. Tischler will take the rest of the day. Mr. Balch is in a board meeting on Monday. So our proposal, the consensus with everyone other than Mr. Knight, who hasn't really, he had left before we had the benefit of having that conversation, was that we propose to skip Monday and then come back on Tuesday and finish Mr. Balch and Mr. D'Antonio on Tuesday.
Thank you, Mr. Wexler. Mr. Knight, I hope this doesn't come as too much of a surprise. How do you feel about this as the petitioner?
They say, how does that make you feel? Yes, the department has no objection to skipping Monday and picking up on Tuesday, certainly with the hope of finishing on Tuesday. Okay. Microphone does. The department has no objection to taking Monday off and picking up on Tuesday with the sincere hope of finishing the hearing on Tuesday. So beyond that, I guess I don't need to say anything else. That's the question that's on the floor.
Yes, thank you.
So with that, I'm happy to either give my position statement. My preference would be to put on Mr. Tischler because he has travel limitations, and I can stay as long as we want, or I'll be here Tuesday and whenever you all want to hear it. If in fact you actually even want to hear me speak. So if I could just take 5 minutes, our computers are shut down now to get his PowerPoint up. Thank you.
All right, let's do that. I think you're right. We need to prioritize the witnesses. It's going to take them a few minutes. Pam, does he have sharing authority? Does he have sharing authority?
Madam Hearing Officer, and this is a question perhaps for Mr. Wexler. The NMOGA witnesses have taken 6 to 8 hours for their testimony, rebuttal, and cross. Is it reasonable to expect that we can do 2 witnesses on Tuesday?
Well, we're certainly willing to shorten our initial presentation. We obviously cannot control questioning and cross. Given the pace we've gone at thus far, it's perhaps unlikely. I acknowledge that.
So that would leave us to finish on Wednesday, which I believe we have the room reserved for that day.
And all parties had agreed to hold Monday, Tuesday, and Wednesday for this hearing.
Okay, thank you. You wanted to? I was.
Am I presenting now? Yep. Let me just go to present this slideshow. Okay. So it looks different than what I'm looking at on the screen, but it probably is fine.
So you know what,
Did you-
Jeff, yesterday, Carrie and I worked on it, and could not get it to do the usual slideshow
so
thing.
just do it for
So
me.
you have to press each slide like that
Okay,
on the left side.
I can do that.
Okay, are we ready?
We are ready.
Okay, so we're back after a short break for council and the next witness to set up. Thank you, Mr. Wexler. And sir, if you would state and spell your name for the record, please.
Ma'am,
State and spell your name for the record, please.
my name is Lyle Ishler. I didn't get the second part of your question.
Spell it.
I'm sorry?
Spell your name.
Oh, spell it. Lialtishler.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Wexler.
Thank you. Good afternoon, Dr. Tischler.
Good afternoon.
Could you please summarize your educational background?
Yes. I have a Bachelor of Science degree in Civil Engineering from Texas Western College, a Master's of Science in Environmental Health Engineering from the University of Texas at Austin, and a PhD degree in Civil Engineering from the University of Texas at Austin.
Thank you. And I think the court reporter is just asking us both to speak loudly and slowly.
Okay.
Can you please summarize your professional background?
Yes. I received my PhD in January 1968 and then had a 2-year tour in the Army as an environmental engineer. I left the Army in 1970 and became a systems engineer and ultimately director of systems engineering at the Texas Water Development Board. In 1973, I changed jobs and went to work for a consulting engineering firm named Engineering Science Incorporated. And my experience has mainly been in consulting in water and wastewater treatment, water quality impacts, and analysis using computer models. In January 1986, I, with a younger member of the firm, formed our own company. The name of the company is Tischler Kasurik. We are a partnership. Both of us are licensed professional engineers, and we have been working essentially in the consulting field in industrial wastewater treatment, water quality analysis, and impacts analysis. We don't do much in actual design. Most of the work we've done is studies. We have extensive experience working at both the state and federal levels in the development of water quality regulations, hazardous waste regulations, and certain aspects of air pollution regulations. Most of this work was done on behalf of trade associations such as the American Petroleum Institute, the American Chemistry Council, and the Pharmaceutical Research Manufacturers of America. And as I say, we've been in business, the two of us, for 38 years, and we're still going.
We have before you what has been previously marked as NMOGA Exhibit number 13. It's entitled Your Rebuttal Testimony. Was that rebuttal testimony drafted by you or under your direct supervision?
Yes, it was.
Is it true and correct to the best of your knowledge?
Yes.
And if you were asked the same questions today under oath, would you provide the same answers?
Yes.
I'm going to offer to admit it at the end of his testimony. I understand, Dr. Tischler, you also have a summary of your rebuttal testimony. Is that right?
That is correct.
And at this point, I'll ask you to please walk us through your testimony. I'll go ahead and operate the PowerPoint here. So just let me know when you want me to change slides.
Okay. Basically, I will try to go through this relatively quickly because I know this has been a long hearing process. I appreciate the commissioners in hearing examiner having me here to offer these comments on behalf of NMOGA. First, I want to just say important part of water reuse is that it's a proven technology. And as such, both domestic sewage and industrial wastewater is essential to reuse in water short areas. Using as an example, municipal wastewater reuse is a proven application. It's being accomplished in a number of locations. For example, in Texas, the regulations authorize reuse of municipal and industrial wastewater for many applications.
I think if Mr. Wexler turned off his mic, it would help.
Okay. It sounds very loud to me. Is that better? No, I mean, I'm actually hearing a bit of a feedback myself. Okay, I'll back up a little bit. I'll just make it short. Essentially, domestic wastewater and industrial wastewater are being reused right now. They're an important and valuable resource. Municipal reuse is far ahead of the reuse that we're talking about of produced waters, but it's a matter of time as more technologies developed and the existing technologies are improved, where we can basically come to a point where virtually any type of wastewater, we can recover the water for just about any use that we would look forward to using. In New Mexico, especially, water reuse is essential, and that's already been testified to, particularly in southern part of the state and in the eastern parts of the state that are very dry to begin with. Potential use of produced water as industrial applications and indeed in other applications as the technology is improved can really offer additional opportunity for wastewater, for water supply in New Mexico. The discharge prohibition that is in the proposed rule is not justified by the rulemaking record. NMED's and NMOGA's testimony supports the fact that technologies currently exist and can be improved upon, and it can treat produced waters to a quality acceptable for discharge to surface water or ground application to the ground where it would end up potentially affecting groundwater or for reuse in industrial applications. We've had extensive testimony over the last 2 days about the technologies involved in treating produced water to a level of water quality that can actually be essentially distilled water quality. I'm not going to go into that aspect at all because you've had extensive testimony from experts in that. What I want to emphasize is the fact that we have the ability and we're moving towards better opportunities to treat water, produce water to levels that are acceptable for just about any use that we need in New Mexico. What is the problem with the microphone?
I just want to make sure it's off.
Yeah.
Thank you, Sergeant.
Some of the statements that have been made suggest that produced water is truly unique in terms of the number of pollutants and that need to be removed in order to make the water acceptable for reuse. It is unique only to the extent that it has very high TDS concentrations, which have been testified to, and it also contains radioactive materials, naturally occurring radioactive materials. But other than that, the number of different chemicals that are potentially present are essentially no different
than what we see in a number of other wastewaters, both industrial and municipal. It's the inorganic salt concentration, which was testified to by the previous witness in terms of the technologies that are being developed to remove those salts. And in the end of the day, we're interested in the water that we get after treatment of produced water. The constituents in the produced water before we apply various treatments are important only to the extent of selecting the types of treatment technologies we need to use. We can produce water with technologies that we have now that is essentially acceptable for almost any use. As an example, all the constituents in produced water, other than the TDS and norm cited by NMED and advocacy group, can occur in any kind of single water source. Formation water from different locations will have different naturally occurring constituents. They're not all the same in every even within the Permian. They're not, the wastewater, the produced water is not the same quality. The source of water used in drilling and well development will have different constituents at different locations, and the additives used in drilling will be different. But all of that information can be obtained by NMED as part of the permitting process and evaluated to make sure that water that is treated is going to be protective of human health and the environment, regardless of the particular use that it's going to be put to. I'm using municipal wastewater treatment plants as an example because they treat a range of wastewater sources that include industrial sources, they include hospitals, they include a number of different operations other than just normal residences. And they contain disinfectants, cleaning products, pesticides, personal care products, and pharmaceuticals. I mean, these discharges are just as complex in their own way, yet we don't apply the same level of evaluation to those because we know that the existing treatment systems have generally been proved to be adequate. But there is a huge amount of work being done by EPA and others with respect to things like pharmaceuticals and personal care products in domestic sewage. So in that way, I'm only using that as an example to say, if we can deal with it in domestic wastewater sewage and we allow treatment, discharge, and reuse of domestic sewage, there is no technical reason nor regulatory reason that you can't apply the same level of analysis to determine whether or not a treated produced water is in fact acceptable for any particular targeted reuse. I'm going to just skip over this slide because I've already talked about the fact that domestic sewage has a wide range of materials in it. In general, the typical wastewater treatment plant used for municipal sewage, such as that for the city of Santa Fe or the Albuquerque area, provide a relatively simple level of treatment. And we don't really look for the same kind of pollutants, the levels that we're looking at for what have been talked about here, the NPDES plus list of 400 pollutants. I can pretty much assure this panel that in fact, if you were to use the same sort of level of scrutiny in terms of analyses, you would find hundreds of pollutants that are still at trace levels, and we're talking about numbers in the nanograms per liter or even low micrograms per liter in a domestic sewage effluent, well-treated effluent. And this is well known, but yet we are able to take those municipal effluents and treat them for reuse. And I skipped over it, but for example, the city of Big Spring in Texas does use essentially now direct potable reuse to supplement their water supply. For comparison, the amount of domestic sewage discharged is really large. The Albuquerque Southside Wastewater Treatment Plant discharges over 46.8 million gallons per day into the Rio Grande, and yet we only limit a relatively small number of pollutants, even though the downstream water uses include aquatic life use, livestock watering, public water supply, wildlife habitat, and primary contact. The reason we allow that is that our experience with domestic sewage is that if we set permit limits that the treatment plant can meet, we generally are confident the human health and the environment, including all the various uses like irrigation and wildlife, are being achieved. So we can skip over this next one. I just want to basically say it's not, I've been doing consulting engineering water quality analysis in the wastewater field for over 50 years. We have learned a great deal about the technology that we can use. And those technologies are now being incorporated into treatment systems to improve the quality of effluents, to better protect the environment, but really to look at the ability to reuse water in multiple applications, including whether it's irrigation or as a part of industrial water supply, for example, cooling water in industrial plants. We have all these options available to us as the technologies can continue to improve. I want to talk briefly about how EPA sets their effluent guidelines, because these effluent guidelines are national standards that apply to certain categories of industry. One of them is the centralized waste treatment category, which is the one that is currently being used in some states to authorize the treatment and discharge of produced water to receiving waters. And I think Pennsylvania was given as one of the examples of where this particular effluent guideline is being used. What EPA does, and this was built in the 1972 Clean Water Act, which adopted this national technology-based level of treatment for different industrial categories as well as for municipal wastewaters, is they set these effluent guidelines by collecting data for a particular industrial category, like petroleum refining, central waste treatment. They will collect this data and analyze it to determine the technologies that are acceptable for treating this wastewater to levels that that represent state of the art in terms of best available technology or best practicable technology. It's a multi-year process where they collect data from industry and from others, including data that EPA collects itself by going out and doing special studies where they measure a wide range of pollutants. And ultimately, they develop and promulgate these standards. And these minimum standards apply nationwide to each particular industrial category for which they develop the standards. There are actually standards for oil and gas extraction at 40 CFR 435, and those are for wells in certain parts of the country, and I think it's been testified to in Wyoming and in Texas. There are in fact permits that allow discharge of produced water to surface waters of the state. In addition to the technology-based limits, the Clean Water Act requires EPA to set guidelines for states to develop water quality criteria, which in turn are used to develop water quality-based effluent limits to assure protection of all uses of surface waters. Now that can apply equally to the way these rules are written to protection of groundwater, because basically what you do is you set standards for all of the constituents that you believe need to have standards to protect all the designated protected uses, human health through drinking water or through exposure through the food chain or aquatic life through direct exposure. New Mexico has adopted water quality standards pursuant to the EPA national criteria at 20.6.4 MAC. They have designated uses for receiving waters, and all the discharges must assure, all discharges that are permitted in this state through the NPDES permitting program, which currently is operated by EPA Region 6, have to be protective of all the designated uses. Once EPA develops a NPDES permit to authorize these uses, NMED, first, it must determine what technical-based effluent limits are applicable. And they don't have to just follow the guidelines. They can set what are called best professional judgment-based technology limits. For example, using data that industry provides on the technology that they propose to use and its performance in order to meet the treatment limits that are technology-based. But then we layer onto that what are called water quality-based effluent limits for any constituents that have water quality criteria, or for constituents that the state determines need to be regulated in a permit in order to protect water quality in the designated uses. Those are also supposed to be added into the permits. The result of this process is you end up in a properly designed and authorized NPDES permit with limits that are reflective of that particular effluent discharge, limiting the constituents of the discharge. You can't limit the volume of the discharge. It can have special conditions that require studies to add additional data to the database so the permit can be reopened as necessary, which is actually a common practice in some states. So the NPDES permitting program is a tool which can be used to be sure that you achieve the protection that is required by the Water Quality Control Act. The result of this is that a properly prepared, reviewed, and adopted NPDES permit should be protective of all of the water users and also represent the best technology that's available for the pollutants that are present in that particular wastewater stream. I mentioned already, all discharges of wastewater to waters of the U.S. must be permitted under the NPDES system. This does not have to mean that the permitting is only limited to waters in the U.S. For example, many states, Texas, Oklahoma, and others, they apply the same permitting program to surface waters that are not waters of the U.S. and to waters that are not connected to waters of the U.S., such as playa lakes and the like. There is no limitation on the state for extending their permitting program to all discharges of surface waters, and correspondingly, they can use the same procedures to extend those protective permit limit conditions and requirements to groundwater pollution, from the use of land application for disposal or use of water for irrigation. So there's a protective mechanism in place under the permitting systems that states can adopt. And in fact, if they become authorized as NPDES permitting states, then they have the authority to basically prescribe in the permits not only what information has to be provided by the permit applicant, but also what the conditions are going to be as the permit is effective and the operations facility is resulting in the discharge, whether it's discharge to the land or discharge to the water, what samples they have to take, when they have to take them, and what they have to analyze for. There have been questions about chemicals that are used, for example, in fracking, and confidential business information in the way to determine whether or not a particular set of chemicals at a given level of concentration may be potentially toxic. Permit applications in almost all of the states that have the permitting program require the submittal of safety data sheets, which have been discussed before, for every chemical that is believed to be present from the operations of the facility in the effluent. And not only have to provide the safety data sheets, the applicants in many states are also required to provide estimates of the dosages and the usage of the particular chemicals in which process they're used in, and the likelihood of their presence in the effluent. States can then use that data to put in additional requirements. I think it was discussed earlier that states can, in fact, take the position they will not authorize a permit for discharge for any chemical for which an SDS or equivalent information is not provided. I think Mr. McGirt, Rick previously stated that Wyoming had a requirement like that, and Texas basically has a similar requirement. One of the things about the NPDES permitting process, which again is applicable to any permitting process, including groundwater, is that all of the proposed NPDES permit conditions and the underlying technical and regulatory analyses must be available for public review and comment. Different states have different levels of public participation requirement, but as a minimum, required by the NPDES regulations, they must have at least a public notice on the draft proposed permit, and including with that the fact sheet, technical development information that was used to develop the conditions and limits of the permits. Some states, Texas actually has a system where there are two public notices that require notice not just for in the newspaper, but also direct contact of any individuals that are landowners that are within 1 mile downstream of a stream, and the entire area surrounding the property where the operations that result in the discharge are taking place. And if it's in a tidal regime, it's also upstream as well as downstream. That landowners must be notified by letter twice when the permit application is submitted and when the draft permit is proposed. And all the public is entitled to get copies of the applications. In fact, in Texas, the application has to be placed in a public library in the area where the permit's being issued. So there's ample opportunity for the public to obtain the records and review the records that the state is using to develop the NPDES permit. And when EPA develops the permits, as they do in Region 6, then they are the ones that require the publication of the public notice, and it's not quite the same process. But the reason I'm discussing what Texas does, other states do similar things in terms of public participation. It's up to the state to make it available to the public what they believe the public needs to have in order to comment and be involved in the permitting process. Now, NMED is not currently authorized to issue NPDES permits, but they have to there's what's called the state certification process. They have to certify the EPA that any proposed NPDES permit has to be protective of all designated uses. And in doing that, NMED has not only the right, but the duty to recommend denial of a permit if they don't think it's protective of water quality and designated uses. So there's no reason to have a prohibition on the discharge of any particular wastewater stream, whether it's a treated produced wastewater, whether it's an industrial effluent or domestic sewage effluent, given that there's a process available that would allow that the public or the governmental agency to simply not issue the permit. And if there's no permit authorization to discharge, that discharge can't happen. That process exists. It's existed since the Clean Water Act was adopted in 1972 for surface water discharges, and it could be equally applicable to ground discharges to groundwater should the state choose to incorporate that kind of language in their permitting process. That basically summarizes the testimony that I provided in terms of the written testimony. Again, but just like to emphasize that there's a nationwide permitting program that's been in effect for basically almost 60 years, that for discharges to surface waters, including surface waters of the state, should the state choose to adopt the coverage for those, that gives the state ample opportunity to prevent the discharge of any particular wastewater stream that is not protective of human health and the environment. And so I would contend and offer to you, the commissioners, that the prohibition that's in this proposed rule is unnecessary because, in fact, the tools are available to the NMED to be able to prevent any problems to human health and environment from any specified use or reuse of treated produced water. And again, I'm talking about treated produced water. I want to emphasize that again. I'm not arguing here that there's any, that the salinity issue with respect to the discharge of produced water that's untreated is not currently an issue that has to be dealt with before water that is acceptable for all different types of reuse is then made available by additional treatment. Thank you very much for your attention, and I'm pleased to offer these comments.
With that, Madam Hearing Officer, we have no sir rebuttal, and so we would offer Dr. Tischler for questions from the commission and the parties.
All right, thank you. Commissioner Zemlich, do you have questions of Dr. Tischler? All right, Commissioner Fry.
No questions, thank you.
All right, Commissioner Dominguez.
Still forming up.
All right, I will come back to you. Are you in the same position, Chair? Oh, yeah, oh, you're ready. Okay. Get ready, Dr. Tischler.
I'm ready. First of all, thank you for your testimony. Thank you for coming all the way from Texas. Pleased to have you here. We don't want you to take any of our water.
Well, just so you know, Mr. Chairman, I actually have a close association with New Mexico. I graduated from Gadsden High School many years ago, so, and a frequent visitor to Cloud Crawl.
Welcome back. So I especially appreciate your comments about municipal wastewater reuse. Our regulations call it domestic wastewater reuse, but it's clear from your testimony, you recognize that there's more to it than just household waste. You mentioned hospitals and light industry and other contributors to the wastewater collection system. Isn't that correct?
Yes, sir, that's correct.
So that makes it complicated. And I believe you testified that the chemical composition of municipal wastewater is very, very complicated.
It is very complicated. I mean, you could just look at the question of pharmaceutical, because as most of you may be aware, actually pharmaceuticals are most of the pharmaceutical products we take, other than those that are injectables, they basically are designed not to break down. So they do end up in the treated effluent. And that is a big focus of work that's being done in the European Union, as well as what EPA has been looking at for years.
Yes, yes. There's more to it than pharmaceuticals, isn't that?
Oh,
correct?
yes. I mean, the term that EPA has used is pharmaceuticals and personal care products, but there's also pesticides, there's household cleansers. I mean, one only needs to look at the label, something like just a hand washing soap, and you will see that there's at least usually 7 or 8 different kinds of chemicals, including disinfecting chemicals and various emulsifiers and other materials that are, again, we believe them to be relatively innocuous. They're used, by humans to wash our hands, but the fact is that those do all show up in sewage.
And other things that familiar products like caffeine that shows up in wastewater.
Caffeine we actually use as a tracer for whether or not we're getting sewage in an industrial treatment discharge. If you can imagine that, we actually can test for caffeine when we're concerned that our industrial sewer is cross-contaminated with our domestic sewer, a sanitary sewer, I should say, at an industrial plant. Caffeine is a marker, and it is found everywhere.
One of my favorites, that is notable, the little yellow packs of Splenda. That's an artificial sweetener, contains sucralose. Is sucralose, are you familiar with sucralose?
Yes, I am, sir.
Is that degraded in conventional wastewater treatment?
I am not aware of any real effort to evaluate sucralose, and I'm not sure that sucralose per se, we actually have an approved analytical technique. I think we can measure it as it could be measured by certain of the analytical techniques we use, but there's probably not an approved method for it. So there's not been a lot of work done on something like that I'm aware of.
That might be one of the non-targeted compounds that we've talked about.
That would be an example of it.
You mentioned Big Spring, Texas. It is a community that practices direct potable reuse.
And when I say direct, they put the water back in, the treated effluent back into their lake that they then pull water out. It's not a closed loop with the water treatment plant.
And the lake serves as what is commonly referred to as an environmental buffer. Is that correct?
Yes, that is correct.
So it's a mixture of the treated wastewater and the native water.
And what little water is actually, if I recall correctly, this particular lake, they pump water into it for, I think they pump groundwater into it because the Red River is fairly salty.
That's for sure.
Oh, I said Big Spring. I'm sorry. It's not Big Spring. Big Spring is Comanche. I think it's a creek.
It's a
I
creek.
was I was confusing Big Spring with.
I don't remember the name of the creek. I appreciate you bringing this up. It's something that I've referred to several times. The proposed rule addresses three types of reuse: produce water, which has attracted most of our attention, industrial wastewater, and domestic wastewater. Does Texas have regulations that deal with non-potable reuse domestic wastewater?
Yes, they do. And that's how, I mean, those regulations actually been in place for a while, although if I recall correctly, and again, I got to be a little careful here because I don't deal directly with municipal water supply and municipal wastewater treatment very much, but they do have regulation that they use to authorize the water reuse at Big Spring.
Well, but the water reuse at Big Spring would be potable reuse. I'm talking about non-potable.
Oh, non-potable. Oh, yes. There's a whole section of the Texas Administrative Code regarding reuse of both industrial and municipal wastewater. For example, and it's by classes depending upon the type of industrial wastewater. For example, in the municipal I'm less familiar with, but like industrial wastewater, if it's water that's for like cooling water tower blow down that has a TDS below 2,000, then you actually don't even have to permit it. You have to keep records, and you can irrigate with it. You can't reuse it. You can reuse it, of course, back in the cooling system, but you can irrigate with that water for landscape irrigation. Then there's another level that if you can use for industrial process wastewaters that are not in certain industrial point source categories that EPA had. So, for example, you can't, under this second level of reuse authorization, you can't use wastewater from petroleum refining or organic chemicals for reuse. But if it's from processing vegetables or something like that, you have a second level of permitting and reuse is allowed. Then the third level is where you actually have to treat things that have to meet the effluent guidelines. But they do allow reuse of water if you've got an effluent guideline, and if at the effluent guideline, they will allow reuse of that water generally for industrial use.
Thank you. I'm not too interested in the details because we could go, no, that's fine. I really don't mean to cut you short. But the point I was hoping to clarify was Texas does in fact have well codified regulations that deal with non-potable reuse.
Yes, sir, they do.
Do they have regulations for potable reuse?
Those are the ones that I was mentioning. They've developed, yet they don't. They have the regulations that they authorized Big Spring under. I can't speak to the exact details of those regulations, but of course, as you're probably aware, because they're neighboring, city of El Paso has been, reusing water by treating and then re-injecting. They actually desalinate some of their effluent and they re-inject it into the aquifer that they had pump out of. They've been doing that for like 20 years. And so that's authorized by rule.
The El Paso system at the Fred Hervey plant is considered indirect potable because they discharge to a buffer. That's
right. They re-inject it into the aquifer.
Does New Mexico have rules that deal with non-potable reuse? And if you're not,
no, I'm not familiar enough to.
That's fine. I'll ask NMED. Does New Mexico have rules that deal with potable wastewater reuse?
Again, I don't know. I didn't specifically look at that.
Okay, well, in fact, that's the reason for this proposed rule, so the answer is no. Um, But again, thank you for bringing it up. And let's talk about the discharge. And you talked about effluent limitation guidelines and technically based effluent T-bills, technically based effluent limits.
Yes,
Those apply to surface water discharges.
that's correct,
They're developed by EPA.
sir.
And if a facility, municipal, industrial, oil and gas facility, if it discharges to a water of the U.S., they are required to have an NPDES permit.
Yes,
And the NPDES permit will have criteria that are based on the effluent limitation guidelines and the T-bills.
at a minimum, yes.
Okay. Now, a couple of years ago, we've got a new definition of waters of the U.S. You're familiar with those?
Yes, I am.
Do you know if there are any federally identified waters of the U.S. in southeastern New Mexico other than Pecos River? Playa Lakes are not,
I'm thinking. I believe that certain tributaries to Pecos River certainly are waters of the U.S.
I think that's true.
For example, Rio Penasco, which is up near Cloudcroft. I know that is. Well, of course, the Rio Grande is waters of the U.S.
I'm
But
specifically,
you said in the eastern part of the state,
yes.
and beyond those, I'm not aware of any that meet the new definition, the revised definition by the second decision as waters of the U.S.
So if a facility had a discharge to apply a lake, would they require an NPDES permit?
Not under, as I understand it, current New Mexico rules. Texas, the answer would be yes, because they basically regulate, they call water of the state. And for something like a discharge into a playa lake that is closed system, you get a state permit. For discharge into, and this is where the question comes, so-called ephemeral streams, they've always issued TPDS permits. Indeed, probably every municipal plant on the west side of the Pecos River has a TPDS permit if it has a discharge. And all of those streams would no longer under SACIT be navigable waters and waters of the U.S.
I appreciate that. And I think this is probably a little bit out of your area, but I'm trying to make a determination if a discharge to a surface water that is not water of the U.S., it would not be subject to an NPDES requirement
Not under the federal rules, it would
under the federal rules. Yes, and so those effluent guidelines and the T-bills, technically based effluent limitations, would at least, they might be good guidance, but they're not requirements if an NPDES permit is not required.
That's correct.
Okay. you claimed in your testimony and as well, both your written testimony and specifically your oral testimony, that produced water can be treated to distilled water quality. I think you also said it can be treated for almost any use. Is that correct?
That's correct.
Can you give us citations of examples of operating facilities, pilot plants, papers, white papers?
Well, some of that has already been introduced, but basically what I'm saying is that technically speaking, if you don't take in cost effectiveness, we can make pure water out of almost any water. For example, distillation can basically remove the salt. Activated carbon, ion exchange, and reverse osmosis can remove essentially everything to take it to distilled water. I mean, we create and spend a fair amount of money for it, lab water that is, as was mentioned by Mr. Aaron, water that is completely deionized and has no distillants in it. It is a matter of economics. But from a strictly engineering technical standpoint, we can produce pure water. That's the statement I was making, sir.
Okay, and I don't dispute that. I just wanted to know if there are examples of facilities at any scale, bench scale, pilot scale, or demonstration scale that you can specifically point to where it has been done
For produced water.
for produced water.
The answer is no, because you already heard the testimony.
Okay.
Previous witness testimony was thorough.
I am done. Thank you very much.
Thank you.
Okay, thank you, Mr. Chair. Commissioner Dominguez?
Thank you, Madam Hearing Officer. Thank you for your testimony today. I'm going to circle back to your previous testimony about domestic wastewater and some of the Q&A you had with the chairman here. So you were here this morning when Mr. McCurdy was cross-examined by the Environment Department, weren't you?
Yes, sir.
Do you recall the questioning that centered around the Water Quality Act's authority to deny a permit?
Yes.
And to somewhat summarize that it alluded to the authority to deny a permit was based on either state or federal standards that were established. Is that what you had understood from that?
Yes, sir. That's what I heard. And I have read the regulation, but I haven't committed it to memory.
Okay, so if I'm understanding your testimony where you've talked about domestic wastewater and the amount of unknowns that are in domestic wastewater, are you implying that some of those unknowns do not have standards?
Implying, sir, that virtually all of those unknowns don't have standards. And again, I would use the easy one, which is the pharmaceutical products.
Okay, so if this commission was applying the same logic to domestic wastewater permits, since there's not standards for part of them, then there's not the authority to deny that permit. Is that what you're implying in your testimony?
I don't mean to offer up the suggestion that, but I think it's an obvious question that, yes, I mean, if you take the same position and apply it equally, you would have a problem with the permit for the municipal facility.
Okay, thank you. That's all the questions I have.
Thank you. Commissioner Bayless. Okay, Commissioner Branker.
No questions.
Commissioner Vihel.
No questions, thank you.
Okay. Going to the platform, Commissioner Rosatos. You may have stepped away. Vice Chair Armstrong. You may have stepped away. And Commissioner McWilliams.
Morning or good afternoon, I'm sorry. Quick question, only one today. Yesterday, or actually 2 days ago, we heard from Dr. Van Gosh that he believes the rule should have more specific protective standards included in the rule. Is it your opinion that this rule should also include specific standards?
I believe setting standards that are clear is appropriate for the rule. I would qualify that by saying that, and my written testimony discusses this, it's virtually impractical to set standards for 400, 500 chemicals. Instead, the methodology that EPA is used in the effluent guidelines, which I think Mr. McGurn referred to as surrogates, but EPA calls them indicator pollutants, that indicate the level of treatment that can be provided for a wide range of compounds. I'll give you an example. In the petroleum refining industry, certainly petroleum refining wastewaters contain dozens and dozens, if not hundreds of different various chemicals that are related to petroleum. But EPA has made the determination for their effluent guideline that by controlling two parameters, chemical oxygen demand and total phenol, that they get sufficient treatment, that they can monitor for those and determine that all the other pollutants are being reduced to levels consistent with best available technology. So this is a rather, I'm sorry, drawn out answer, but I believe that standards can be set, but I don't believe they have to be set for an enormous number of compounds, which would be a tremendous burden, whether it was on a POTW, publicly owned treatment work, or an industry or produced water, in order to do routine monitoring to show compliance with the level of technology that you believe was necessary to protect human health and the environment.
Understood. Okay, that's all my questions. All my
Can I
questions
answer your
for now.
question? I mean, I know I drew it out a little bit.
Yes, I believe you did. Thank you.
All right. Any other commissioner questions? No. I think we should take a break before we begin the party cross-examination. Let's come back at 2:40.